of 500%.
Ignore that example. I'll make it good on other.
Suppose some state levies rates at the rate of say 300%, something disproportionate, which will really affect the industry, and that state is the primary source of that mineral in India. Parliament can certainly regulate the rates. When you are prescribing limitations, you can say that, look, rates will not exceed so and so. Rates on this mineral will not exceed so and so. You can have differing limitations for differing minerals.
So please ignore that example for the time being.
Union is not thought through how they can use the limitation power, imposing power, to ensure that whether states are not restricted in imposing taxes, the taxation structure in the states does not affect overall the development of the mineral or the development of the industry. Parliament can still do it, but they'll have to do it then in a nuanced case by case, mineral by mineral basis.
That is where we would respectfully argue. Next and the most important thing, as I would show from one report, which is prepared every 3 years. Your lordships are aware, section 9 provides that the royalty will, the rates of royalty would be changed every 3 years. So there is a report prepared. It was really heartening to know
yes,
a classic example of cooperative and collaborative federalism. So what the central government does, your lordship did not write, in my note, your lordship would find everything. We call for the views from all stakeholders. Stakeholders would mean industries, stakeholder would mean people who are going to be affected by the industries, because ultimately we have to protect the environment as well, and essentially and more importantly, the state governments. I'll show from the last report of 2019 that the state very effectively involved in the process. They say that this particular mineral, bauxite, please increase it by 2% because this is our revenue generation. These are the reasons why it should be something more. Then, I'm sorry. Then the subgroup, after receiving all these detailed inputs, examines what are the global scenario, what will be the impact on the export-import. All these minerals are required for the core industrial sector of the domestic market. That is taken into consideration. The core industrial sector is the heartbeat of any economy. So that is considered, and I will show that to your lordships. And thereafter, with reasons why the state's request is either accepted or not accepted, a price is fixed qua each mineral, and thereafter the central government is out of it. Now you collect, you appropriate, you do whatever welfare activities you want to do in your state. The only dispute between the parties, in these proceedings is, after having, it is our case, that when we decide the amount of royalty, the figure of royalty, that is all inclusive, taking into consideration all your requirements. What the states say, that over and above the royalty, we can independently levy certain amount under various names. What we believe and what the Act perceives, the objective of the Act is that whatever I am saying, I'll be able to make good from the record. So suppose iron ore or bauxite, some amount is fixed, say 100 rupee per ton or per whatever, my lord, there are, my lord, pit's mouth value, etc. That also was argued, but I'll show that's not relevant for this purpose. So the amount comes to say 1,000 per ton, giving a absolutely hypothetical example. They say that every state will have a power to levy something more than 100, more than 1,000. We say no, it is all inclusive, and the reason is this: if every state start imposing further levy, in some case it would be 1,500 per ton, in some case it would be only 1,000 per ton, in some state it would be 1,100 per ton. The uniformity of the prices will not be maintained. And I want to flag, my lord, that issue before, my lord, I take your lordships to this, my lord.
Mr. Solicitor, as you are formulating your thoughts, and you have given the example of bauxite, and you say that this rate that is determined, and you said that this is done after elaborate consultation with the stakeholders, including state. And then you say the state is trying to extract over and above the all-inclusive price which you are suggesting to us.
Correct.
Now, taking a cue from the example of bauxite, have you not boxed in the state so far as exercise of their power under 50, entry 50 list 2?
I could not understand the last.
You see, I've said that we have boxed in everything. So, where does the state have the power to exercise under entry 50, their power of tax?
That's my lord, respectful submission that the entire architecture of MMRDA, under which this box price inclusive of everything is fixed, is a limitation on the state's legislative power under 50.
But it's totally denuded, you see.
That's
Power.
my respectful submission.
No, correct.
But otherwise, I'll just give an example, my lord, my lord, why this creates a problem.
Why should the, I mean, just asking, of course, you are just on the starting point.
Yes, my lord.
Why should the act, the statute, not say that this is what the tax that the union is charging, and to this extent the power is denuded or something to that effect? Why are we asked to read this by inference?
Lord, my lord, legal submission would be different, my lord.
We also have the situation of, I mean, I was just discussing Article 265.
I'm merely fixing the role.
That's which will be forthcoming.
It is there, my lord. It is there, my lord. It's invalid text, my lord. Invalid, it would be unconstitutional. But, Lord, I'll be able to show that there is an inbuilt statutory mechanism which says that this amount and nothing more. Otherwise, my lord, what happens? Just give, of course, example would not, my lord, be the basis for your lordships to decide. But I'm just giving an example, the rationale, why, my lord, this is under the central control, the fixation. Lord, suppose there are two states, A and B. A has, my lord, an electricity generation station of a huge capacity. They are using coal as a raw material. B has raw material mines, my lord, namely the coal mines. They say that over and above 1,000 rupee, which is the royalty fixed by the central government, I'll give examples. In many states, India segments, other SAS, education SAS, different nomenclature, was 300% royalty, 500% royalty, etc., etc. So that state A having the electricity generation plant will have to either pay more from state B, because every state has a different price structures.
But Mr. Solicitor, that is implicit in a federal scheme. You see, therefore, unless you say that, look, when you fix, as you call it, an all-inclusive royalty, that royalty includes all taxes also that can be levied by the state. You have to go as far as to establish that.
Correct, Manoj.
That the fixation of royalty is itself inclusive of all taxes, state
and nothing
taxes.
more.
That's one. Second, your argument that, well, it's desirable that there should be uniformity of the price of minerals. It may be a desirable it may be a
It's in
desirable matter as a matter of policy. Question is whether this will impinge upon the federal distribution of power under the Constitution. Now, take another case. Look at, there's several taxes the states can levy under the state list.
My lords.
I'll just give you two examples. Entry 53 of list 2, taxes on the consumption or sale of electricity. Right? Now, in various industries, electricity is not just a medium, but it's a raw material. For instance, in the production of steel, iron and steel industry, electricity itself is a raw material. You know,
It's part of the price structure also.
Right. And now the Constitution contemplates that each individual state can levy a tax on the consumption and sale of electricity. Now, different states levying taxes at a different rate on the consumption and sale of electricity will meet with the same argument that you are urging, that in Maharashtra may impose it at a different rate, Karnataka may do it at a different rate, a solar plant in Rajasthan may do it at a different rate. But that's part of the federal scheme. Or take entry 54, taxes on sale of petroleum crude, high-speed diesel. High-speed diesel is crucial for industry, motor spirit, natural gas. So, if you are consuming natural gas from, say, which comes in from Jamnagar, different rate altogether. If you are importing natural gas, which has come in through, say, a crude pipeline, a gas pipeline, say, in Chennai, completely different rate. That's exactly the scheme of the Constitution. That and there is nothing sui generis about minerals, that there should be a uniformity. Then the same logic will apply to electricity. Have the same rate of electricity, same taxes for electricity.
Ignore that example and I'll give the answer. I'll give the answer. In other entries like electricity or entry 54 list 2, there is no provision like entry 50 that's subject to limitations placed by the parliament under 54.
But therefore, there is a safeguard. Suppose say Jharkhand places taxes at the rate of 500%.
Lord, ignore that example. Lord, I'll make it good on other.
Suppose some state levies rates at the rate of, say, 300%, something disproportionate, which will really affect the industry, and that state is the primary source of that mineral in India. Parliament can certainly regulate the rates. When you are prescribing limitations, you can say that, look, rates will not exceed so and so. Rates on this mineral will not exceed so and so. You can have differing limitations for differing minerals.
Lord,
So,
please ignore that example for the time being.
Union is not thought through how they can use the limitation power, imposing power, to ensure that where the states are not restricted in imposing taxes, the taxation structure in the states does not affect overall the development of the mineral or the development of the industry. Parliament can still do it. But they'll have to do it then in a nuanced case by case, mineral by mineral basis.
My lord, that is where, my lord, we would respectfully, my lord, argue